You're watching Bill on Bankruptcy. I'm Lee Pacchia. I'm joined now, as always, by Bloomberg News bankruptcy columnist Bill Rochelle. Be sure to go and read his daily bankruptcy column. It's available on BloombergLaw.com, and it's also on the Bloomberg terminal. Bill, thanks for stopping by.
Good day.
Bill, I read your story about a district court decision in the Milwaukee Archdiocese bankruptcy, and I got to say, it looks like the sexual abuse victims and the district judge in this case are at loggerheads of sorts. What's going on here?
Well, Lee, you're very polite because that's quite an understatement.
I'm trying to work on that.
Yes, you are. Some people might say that what's going on here is an effort to sandbag the federal district judge. A little background before this becomes evident one way or the other. And by the way, there could be very benign explanations for what's going on here. The Milwaukee Archdiocese, as you know, has been in bankruptcy now for about 2.5 years to deal with a whole bunch of sexual abuse claims. The largest potential asset for distribution to these victims was $55 million that the Archdiocese transferred in 2007 into a trust for Catholic cemeteries in the Archdiocese. The creditors committee, representing largely the abuse victims, contended, no, this is a fraudulent transfer. That $55 million ought to go into a pot for sexual abuse victims. The Archdiocese started a lawsuit for a declaration about whether or not that money is protected. And in January of this year, the bankruptcy judge ruled in favor of the victims and said that the Federal Religious Freedom Restoration Act of 1993 did not protect that money. The Archdiocese didn't take it laying down. They appealed, and guess what? At the end of July, Federal District Judge Rudolph Randa in Milwaukee ruled in favor of the Archdiocese, saying that that federal act did indeed protect the money. He said that the lawsuit brought by the committee would be the equivalent of government action, and therefore the statute kicked in and the lawsuit was dead. As you know, this was a big deal because this was the single largest potential source of recovery. Now, according to the Archdiocese, everybody in the case, including the creditors, has known for more than a year that District Judge Randa is a practicing Catholic. Indeed, the Archdiocese said that it is a matter of public record on the internet that maybe a half dozen or more of his family members are interred in the Catholic cemeteries right there in Milwaukee. The creditors committee are going another step. They want the Archdiocese to say whether or not Judge Randa has purchased a plot for himself or his family members, thereby perhaps giving him an economic interest in this underlying controversy. The committee indicated that it very well might file a motion to recuse Judge Randa or to have his opinion vacated. This is what, to the thinking of some, might raise a situation of sandbagging, where the committee has probably known for a year that there is at least a possibility that Judge Randa might own a plot right there in one of those cemeteries. However, one would have thought, and certainly I did at the time the appeal was being taken, that the creditors had a very good argument and that they would win. But now, as it turns out, they lose. So a skeptic could say that they're now trying to get Judge Randa's opinion killed off on a rather nasty technicality. Now, frankly, all of this, I think, is a tempest in a teapot. I think what ought to happen here, whether there's a benign explanation for this or not, is to take this very important case to the circuit court. This is a really, really important issue about the Federal Protection of Religion Act. And indeed, if this opinion stands, and it might stand or fall in the circuit court, what we have is a pronouncement saying that lawsuits by creditors committees amount to state action. And that, Lee, as you know, is a really, really important constitutional concept about state action. In any event, folks, this is a big deal.
Sure.
And we should all watch it one way or the other, both on the recusal issue, which, by the way, this could well be a case of waiver, where it should have been raised a year ago and not now. But the underlying constitutional issue is huge.
Wild, wild stuff. Let's talk about Judge Jed Rakoff in the Southern District of New York. Once again, he is our Judge of the Week. Bill, what did he do this time to merit this distinction?
Well, it's not what he's done yet. It's what he might do because he has a very interesting dispute. The Madoff trustee was sued a while back in Luxembourg by a trustee for Luxembourg entities claiming they were defrauded by this whole Madoff mess. The Madoff trustee filed a lawsuit in bankruptcy court to stop this suit in the Luxembourg court, and the Luxembourg liquidators brought part of it up into federal district court before Judge Rakoff. What Rakoff is going to decide is hugely important. He's going to rule on an issue arising under a 1987 Second Circuit case called China Trade, which says you have to stop and think real hard before a U.S. court does something that deprives another court of jurisdiction or the power to go forward. If it turns out that Rakoff rules that the Picard trustee in the U.S. cannot stop that lawsuit abroad, this is huge for bankruptcies in the United States, because heretofore it has been the common thought that once you're in bankruptcy in the U.S., that estate or a trustee cannot be sued, get this, Lee, anywhere in the world. Ergo, Judge Rakoff has this case, probably won't be decided for maybe a year or so, on the question of whether or not the Madoff estate can be sued in Luxembourg.
Now we have some stats to run through. Bill, the stats are in regarding July bankruptcy filings. Now, when I talk to people, they say that they are marginally busier than they have been in the recent past. But what do the numbers say? Is there more work out there?
Well, Lee, I think you are a leading economic indicator, and I am a trailing indicator, because the trailing indicators in terms of the filings in July indicate that they're bouncing up and down like they have been for the last several months. And to me, this looks very much like we're at a bottom. So if it's my notion that we're at a bottom and your friends are telling you that they're busier, well, then maybe indeed that is the case and we are experiencing an upturn. Year to date, in all bankruptcies of all types, filings are down 13% through the end of July. Chapter 11s in commercial bankruptcies alone, the filings are down about 24, 25%.
Yikes. Those are brutal numbers.
And those are brutal numbers from 2012, which was pretty meager in the first place. But like I said, Lee, all of this indicates to me that we're at bottom. I can't imagine
it can't get worse.
It can't get worse. And I think you're probably right. Probably is getting better.
All right. Let's close out with the advance sheets. Can't be any more dire news than what we just ran through. This time we're going to the U.S. Circuit Courts, one in New Orleans and the other one in San Francisco. Bill, what did we learn? Well,
first we have Circuit Judge Edith Brown Clement for the Fifth Circuit in New Orleans writing an opinion in a case called Acceptance Loan versus White Transportation. Here she said, following on rather old Fifth Circuit authority, that a secured creditor can ignore a Chapter 11 case and not file a proof of claim, yet have that security interest survive bankruptcy so long as you do not participate in the case. Especially for those of you practicing in the Fifth Circuit, this is a must-read opinion. And by the way, I want to say that I have difficulty squaring this opinion with the Supreme Court's 2010 opinion in a case called Espinosa. I don't have 15 minutes to explain exactly what I mean by that, but for those of you among the bankruptcy nerd colony, I think you should read that decision with Espinosa in mind, but also keep in mind that Judge Clement wrote a footnote where she said that Espinosa did not apply. Then we move over the other side of the country to the Ninth Circuit in California, where we have District Judge Larry Burns, sitting by designation, writing an opinion in a case called Purley versus Fierro. And this, folks, is an opinion that gives good protection to lawyers against malpractice suits arising out of bankruptcy. What he said in brief was that a lawyer's knowledge gained about one client or on behalf of one client cannot be imputed to another client. And here is why that is important. Because, and let me mostly quote his opinion, he said that a lawyer is not required to review his or her files to ascertain whether any other client may also have a claim against the bankrupt. Now, this is really important holding, Lee, because it means a lawyer needn't worry that if you're involved in a bankruptcy case, you have some responsibility to tell other clients about events in that case if those other clients have not retained you. This, I think, is really good defense against, let's call it, unintentional malpractice.
All right, good stuff. Bill, thanks for that. That's Bloomberg News bankruptcy columnist Bill Rochelle. If you'd like to learn more about the cases and issues we just ran through, be sure to go read his daily bankruptcy column. It's available on BloombergLaw.com, and it's also on the Bloomberg Terminal. I'm Lee Pacchia. Thanks for watching.